Those of us as lawyers are seeing how, in a larger sense, the rule of law is being challenged in ways that many of us never imagined. And the Chicago Council provides an opportunity for people to do something about that.
Its work may not be known to the masses, but many have new rights, new opportunities, and new access because of the work Chicago Appleseed has done.
The Council and Chicago Appleseed are dedicated to rooting out invisible injustices throughout our court system and our justice system more generally.
They provide real evidence-based policy advocacy positions based on real data and research.
It really focuses on the small barriers and obstacles to justice that litigants are facing every day.
There are so many ways in which it is difficult to navigate the justice system, and the Council and Appleseed help serve to bridge that gap.
They shine a light on that Byzantine world of courts that I think is really tough to understand.
Chicago Appleseed has earned the respect of all the stakeholders in the courts. Judges, clerks, and defense attorneys know the impact of our systemic reform work and work with us
to create a real, practical solution to solve a problem that affects the most marginalized groups in our community.
Even just one successful systemic reform initiative can have a sweeping impact.
I find that the Chicago Appleseed Fund for Justice is small, but it is mighty.
As a summer intern, I saw how hard the staff attorneys worked every day to fix some of these barriers to justice that members of our community are facing, and they do so with so little resources that in order to affect real change that they're looking for, they need your help.
The collaboration is faced with a lot of uncertainty in these times, but its work is more vital now than ever.
I think the work of Chicago Appleseed and the collaboration for justice is vital for all Chicagoans if we're going to have a true reform of our justice system.
I hope you'll join me in supporting this very important organization
to advocate for systemic change within our court system, to make that system fairer, more accessible, and more effective for the public that it serves.
Hi everyone, thank you for joining us at this Collaboration for Justice panel hosted by the Chicago Appleseed Fund and the Chicago Council of Lawyers. This program is actually part of a month-long series that the Collaboration for Justice is hosting, and you can see all the other programs that are planned for October at collaborationforjustice.org. My name is Maya Dukmasova. I'm a staff writer at the Chicago Reader, and I often report on housing, the courts, and policing issues. So I'm really looking forward to this conversation with our panelists today. So with us are Alexandra Block. She's a partner at Miller, Shakman, Levine, and Feldman, practicing complex commercial litigation, employment disputes, and representation of educational institutions. She also serves as a co-chair for the Criminal Justice Advisory Committee for the collaboration. And she's advocating for evidence-based criminal system improvements such as sentencing and bail reform and modernization of the Cook County Circuit Court and the Clerk of the Circuit Court. Then we have Dr. Mary Patillo. She's the Harold Washington Professor of Sociology and African American Studies at Northwestern University. Dr. Patillo has won several awards, grants, and fellowships, and is the author of 2 award-winning books, Black Picket Fences, Privilege and Peril Among the Black Middle Class, and Black on the Block, The Politics of Race and Class in the City, which focuses on class stratification, community organizing, youth culture, and more in the African American neighborhoods of Chicago. She's currently researching the effects of monetary sanctions in the criminal justice system in the Black middle class in Columbia. Olivia Farrell is the Policy and Advocacy Manager of the Network, which advocates against domestic violence. Prior to joining the network in 2019, Olivia worked with young adults who had experienced foster care in Arizona. She earned her bachelor's degree in political science and women and gender studies from Arizona State University and is currently pursuing her master's in public policy at the University of Chicago. Annie McGowan is Senior Research Associate for the Civic Federation, covering issues of the Cook County and City of Chicago criminal justice systems, with a special focus on public safety and budgets. Prior to joining the Civic Federation in 2016, she earned her master's degree in public administration from the University of Illinois, Chicago, Annie has experience in data collection for the Illinois Department of Public Health's HIV and AIDS program, human services policy advocacy work, and nonprofit development. And finally, we have Ben Riddell, who's the Director of Criminal Justice Policy at the ACLU of Illinois. He's responsible for drafting and analyzing criminal justice legislation and lobbying in the Illinois General Assembly. Ben joined the ACLU of Illinois in April of 2015 after more than 7 years in the office of the Illinois House Minority Leader, during which time he held the position of Deputy Legal Counsel and staffed the Judiciary and Criminal Law Committees. Ben is originally from Peoria, Illinois. Prior to his work in legislature, Ben practiced law in Chicago. So we hope that today will be a lively and interesting discussion for everyone watching. And I'm going to go ahead and open the floor with our first question. So the way that local government institutions, including the courts, are funded is often pretty obscure to the average person. So I'd like for each panelist to reflect what, in your view, is the biggest myth or misconception about what it actually costs to run our court system? And what's the biggest misconception about how much it would cost to run it in a more just manner? So I'm going to mute myself and let's see. Dr. Patillo, do you want to start us off?
Sure, I'll start us off. I think what I'd like to focus on is obscurity and lack of transparency, and to do so from the point of view of those who who are in some ways charged with paying for the criminal justice system. So as you mentioned, I've been doing research on monetary sanctions in the criminal justice system, the fines, the fees, the costs that are sentenced to people who are convicted of everything from traffic offenses to felony cases. And as one judge told us, we've interviewed judges and prosecutors, as one judge told us, even if a judge doesn't use any discretionary fines in the sentence, there still can be hundreds of dollars of fees and costs that a person has to pay. So this is part of how the criminal justice system gets funded. Now, it's been very hard to figure out what proportion of what's sentenced actually gets paid. So in one county that we looked at, it looked like about 75% of what's actually sentenced doesn't get paid. Because disproportionately the folks who are in the criminal justice system are low income folks. And so they don't have the means to pay. And as a result, their cases drag on and drag on with more hearings to try to get them to pay. And then penalties on top of what they're initially sentenced to pay. So I think in my answer, I just want to read one quote. Again, we've interviewed judges and people being sentenced to pay. And I want to talk a little bit about that lack of transparency as something that plagues the folks who are sentenced to pay. One woman in mid-state Illinois said, so why is it that I'm like having to pay all these fees that are underneath here? Like I said before, it's the statutory charge, $75, VCVA penalty offense on that. Then it's got like child advocacy center fee for $15, state police operations assistance fee for $12.50, medical costs funds for $10. What does any of this have to do with me? I had no medical cost. The state police are not the ones that pulled me over, and there were no children in the car when it happened. So it has nothing to do with the children, not to mention it was a felony. So why does any of this even matter? And what is that VCVA penalty? It doesn't even explain what that abbreviation is. So I just will leave that as a kind of voice from the people who are being charged with paying for parts of the criminal justice system, not just the courts, but as you heard, the state police, child advocacy, and so many other things, that transparency surely is not there for them.
And this is a list of things that this person was presented with upon, like as part of her sentence. Yeah, it's usually like a long worksheet with all those line items, with all these dollar amounts. And she was reading, exactly. She was reading off of that worksheet with those dollar amounts alongside it. Okay. Who wants to jump in?
I can go next.
Go ahead.
So I agree in the obscurity and the lack of transparency. And so just from a high level, looking at the court system in terms of all of the different entities that go into it, it's really not one thing. There are so many different agencies and entities that are part of the system that it makes it kind of disparate and hard to keep track of all the different pieces. So for example, in Cook County, there's the chief judge who oversees the circuit court, and then the clerk of the circuit court providing the administrative support. But then there's also the Cook County sheriff, which while that's a separate operation, the sheriff provides support within the courthouses too in terms of security, and the things that go on in the criminal division of the circuit court directly impact then the sheriff's operations of the Department of Corrections. But then you've also got the state of Illinois budget pays for the salaries of the 400 judges in the circuit court. And so sometimes when trying to unpack all of these things, digging into this information just leads to more questions than answers.
Thanks. I can jump in here. I definitely agree with what the previous panelists have said about the obscurity and lack of transparency in the system. I find the question about the common myths and misconceptions exceedingly difficult to answer because I've done some work in this area. I don't know if there's a common thread that people think about how the courts are funded. I'm not sure if it's a common thing that people think about. I think it usually comes to mind in situations where people actually go to court and, like Dr. Patillo described, find out that what they thought was a $400 ticket is actually $1,000, and there are all these mysterious fines and fees added in, and that may start the wheels in their head turning about where all this money goes to, and as Dr. Patillo said, what it has to do with them and their case. I don't know if these are common myths and misconceptions, but these are things that if people believe these things about the court system, then they're myths. They're not true. That these fines and fees are consistent from place to place or person to person. That we have one court system for Illinois. We have 23 judicial circuits, and the fines and fees may be assessed differently in each one. The idea that the user fees model, as I'll call it, is the correct model, so that the people who make use of the court system ought to be the ones footing the bill through fines and fees, and that the way that we do it here in Illinois is the only way or the best way. I think there are other states that have unified court systems that have greater uniformity. So to the degree that people believe those things, that they're not true, and they're myths.
I can jump in next. Yeah. I appreciate and agree with everything the previous panelists have said. I'd like to look at it from the flip side of what Dr. Patillo was examining, which is the impact on affected litigants. I think one misconception people may have is that the legislature or the court systems have done any cost benefit analysis to determine whether the cost of imposing and attempting to collect these court assessments exceeds the revenue generated. It's very difficult, as others have mentioned, to analyze this in the state of Illinois because there is not uniform data collection. But I think preliminary evidence that Chicago Appleseed has developed, and I know Dr. Patillo has done some research on this as well, indicates that in many instances, it costs more to attempt to impose and collect these assessments than is actually generated to fund the court system.
Go ahead, Olivia.
Yeah, I will echo what has been said already regarding monetary sanctions and this idea that they can fund the system. As we know, as we just spoken to, by and large, the cost of collecting and processing these fees eats up a lot of whatever revenue they bring in if they are paid. And I also wanted to speak to this idea that was brought up that some people might believe this is the correct model to charge these folks, even if it did work well. That really is not the case. For instance, in cases of domestic violence, which is what I mainly work with, we see that if you charge someone with a domestic violence case with a fee or fine, that also feeds into their family, and also ultimately we see that victims of domestic violence are also impacted by these fees. When you have these economic stressors, they might still have joint incomes, so you can't really just charge the individual who's facing this fee. It ripples out into the family, into the community, and so this idea of, the folks who are using the system are paying for it really is not the case. A lot of other folks are going to be impacted when someone is faced with a fee that they cannot pay.
Yeah, and I mean, at the same time, though, even as we're kind of becoming maybe more aware of how much, fines and fees feed the system and how regressive they are, I feel like a lot of people who don't have like a direct experience with the courts or the justice system don't have like really a sense of still how short the budgets can be in these spaces. And I kind of would be curious to hear what you think. So in the last kind of few months, especially, there's been all greater awareness about how much money taxpayers and municipalities spend on police. The city of Chicago police budget is $1.6 billion, which is just for the cops, which is the same as Cook County's budget for the courts, the jail, the state's attorney's office, the sheriff's office, the public defenders, the whole civil and criminal legal system in the county. Like every time there's an arrest made by the Chicago Police Department, people are funneled into the system, which is much larger and more complex, yet there's the county budget for it is the same as the city's police budget. So I feel like people have, especially recently, become, started regularly seeing these well-funded, militarized police forces in our cities with all this high-tech equipment. And it's sort of easy to see how, like, okay, we're spending so much money on the police department, and we can see like how well-equipped and well-funded they are. But I wonder if some of you have some examples of like, what does that budget for the court system actually look like? Because when I think about our courts here in Cook County, like I can imagine so many examples of like, you can tell there's not enough money in this space to actually fund like a smoothly running, well-operated machine. So do you have examples of where that would illustrate what the underfunding of the court system looks like and how it plays out like in its most, egregious form? Because despite the fact that people are getting squeezed with these fines and fees, if you're in a courtroom in Cook County, there might be some, you might be wondering where's the money? So I'm curious, if anything comes to your mind as like examples of like what the actual how the actual financial situation of the court system reflects in real life.
I am not an expert in the budget of the Cook County courts, so my answer is going to flip your question a little bit as far as not focusing on a lack of funding or resources, but an overutilization. And the thing I'm thinking of is drug arrests, which are drug charges, which are all felonies in Illinois. There are that's not the case in every state, but in Illinois, simple drug possession is always a felony. And in Cook County, and this is very interesting and very abnormal, this is not the way it's done anywhere else that I know. felony drug cases are actually filed directly by the police who make the arrest. So there is no there's no felony review where the prosecutor steps in and says, is this a case we really want to go forward on a felony with? They can later on dismiss the case, but it gets filed automatically, goes into the system, goes into the courts after an arrest is made. And drug arrests make up, I don't have the latest data, but historically, like more than a third of the cases going into the system. And so, and more we understand that prosecutors, judges, lawyers, criminal legal system actors are not the right actors to be handling complex health conditions like addiction. So what I'm suggesting is that criminal courts aren't the correct place to be dealing with these cases at all. There's 10,000 of them or something that are coming in because the police made an arrest. And if we're looking to use the resources of our court system more wisely, I would suggest we should pick and choose what we're going to use it for, and that things that are health issues ought to be dealt with in a healthcare setting, not in the courtroom.
And I just wanted to add, in addition to the drug cases, to the criminalization of homelessness. So many lower level offenses, trespassing, those kinds of things, go into the courts. When we have done our research, about half of the people that we interviewed in the state of Illinois had experienced homelessness at least once in their lives. And we saw many people who, for example, we interviewed one person who was asking for special dispensation about his fines and fees. And he basically said before the court, I'm living in a hotel, I'm trying to pay this hotel costs, and I don't have money for my fines and fees. And we see this, it's basically a kind of churn. You get paying your fines and fees could move you into homelessness, and then homelessness gets criminalized through various kinds of public vagrancy laws and so on that then get you back in the courts. And we're spending this money on what is really a social service issue, but we're spending it in the courts. And so with a limited budget in the courts, we're spending money that should be going somewhere else. And court personnel just aren't obviously trained to deal with homelessness. So it's a similar story that Benjamin was telling, but with in a different domain.
I would say, going back to your question about lack of funding, or point about lack of funding, I think that it's hard to assess how well all of these government agencies are using the resources that they already have. So the clerk of the circuit court is one of the most recent examples that I've been working on, along with Alexandra Block, looking at that office and what improvements can be made. And it feels like there are a lot of employees, and it's a pretty large budget appropriation each year, and probably hasn't been looked at from an evaluatory aspect in a long time. And so I think it's important that that we don't assume that there's not enough money. It might just be that resources aren't being used in the most effective way, either because it just hasn't been looked at, or that governments are large operations that are sometimes slow to modernize. And so one of the recommendations that we gave in a recent report to for the candidates running for the circuit court clerk is to do an audit office-wide of staffing levels, and to determine whether the personnel that are already in place in each function is actually serving that function well, or whether there needs to be some kind of reorganization to both serve unmet needs that are not being served well right now, and also more appropriately staff these large offices.
Yeah, and I will pick up Annie's thread there and say, this probably goes to your first and second questions. Probably a popular misconception about the court system as well as the clerk's office. And a lot of people don't even know that the clerk of the circuit court is a separately elected official from, from the judges. She is. They have separate budget appropriations, the court system and the clerk's office, but neither one is subject to the Freedom of Information Act in Illinois. So while the general high-level budget goes through the appropriations process, the details of how money is spent are very difficult to discover. And so I agree with Annie that it is a very tricky assessment to make given the limited information. How the operations are really funded and whether different aspects require more or less funding, or how the funding can be rebalanced, because the current leaders in charge of those offices are not very forthcoming about how they are actually spending the money they are being given.
Yeah, so I mean, it seems like all of you are sort of challenging the notion that the courts are underfunded, because when you can, if you are seeing something in the courts that looks like there's not enough money, like, I don't know, things that come to my mind are like, you know, not enough language interpreters and not enough languages even having the, you know, somebody there that can interpret them, or, you know, all of the different, the length of time it takes to get stuff from the courts.
Right. I was going to say, I do want to make sure that we get to many of those things. We don't know if it's because of underfunding or inefficiencies, but it's super important to say that people spend far too much time sitting in Cook County Jail, for example, for their case to be heard in court, ultimately for the prosecutors to be able to do the work that they need to do. Defense attorneys, public defenders are completely overworked. And so the length of time that people are sitting in jails waiting for the ultimate disposition of their case is far too long, for example. So that's one of the things that you're talking about. And you've raised the other one about language interpreters, for example. People in the, I'm sure Olivia can speak to this much better, but the advocates who go with victims for domestic violence cases, those are places. And we might think about, I don't like the police and the courts being the front line of social services, but in this moment when they are, that's a place where if there were the money to actually be the intake for drug counseling and so on, there are people whose part of their sentence is that they need to go to drug counseling and then can't get spots in programs, for example. So all of those kinds of things, I think, Maya, perhaps is what you were trying to get us to talk about, which is super important to get on the table. But I think as observers, advocates, and researchers, we're very frustrated that we don't have the best information to make those proclamations because of the lack of transparency. And so we kind of touched on those things too.
Yeah, I'd like to jump in. I would echo that understanding why we have some of these failures in the court system is very complex, as we talked about in the very beginning, this idea of like lack of transparency and not knowing where the funding is going, and overutilization. We talked about monetary sanctions and the amount of resources that go into trying to collect those. But I would also want to highlight some of the other problems we see in the courts. You know, with COVID especially, there was a lack of communication of when the courts were even open and folks trying to utilize them, not knowing, lack of timeliness in filing paperwork. We have folks who are trying to get orders of protections that should be filed immediately, but they're not hearing when they're being filed. And in many cases, it's weeks later. And, you know, that's putting them at risk when they are relying on these resources. And we can talk about relying on other resources. But as far as when folks are trying to use what systems we currently have, they do fail in a lot of ways. And a lot of that is just, things not happening in a timely manner with cases and paperwork being lost in the shuffle, and, advocates and lawyers and all these folks having to track down where a case is in terms of its status.
I'd like to just jump into one, underscore Alexandra's point about FOIA and the sort of legally enforced lack of transparency around the courts, which is a problem in so many areas. But one concrete example I can give, in Springfield, where I spend a lot of time, or did at least before the pandemic hit, one of the robust debates that's been going on has been around the use of cash bail and whether it should be replaced, whether we should reform our pretrial system. And so currently, 10% of the bonds that people pay, the monetary bonds, are kept by the clerk's office as a funding source. This is money that they pay that is supposed to be paid to secure people's appearance in court, but it's actually, part of it is being diverted to fund the court system. And, in the debate in Springfield around that, some of the legislators that are interested in going a different direction and moving away from the use of cash bond have asked the question, well, how much money are the courts getting from this in each circuit? And and meanwhile, the circuit clerks are complaining that, we don't have a problem philosophically with getting rid of cash bond, but you're gonna bankrupt our court systems. We depend on this money. And then they're asked the very simple question, okay, how much money do you need to make you whole if we were to get rid of cash bond? And they go silent. And so that question that elected representatives have been trying to answer for years now, to get a basic answer of how much is each circuit getting from cash bond paid by defendants to fund their system, they don't get that answer. And we can't do a FOIA. So that's just a really concrete way that the lack of transparency plays out. And it seems like if we're going to give the courts more money, we need to know how much money they're getting now.
So this actually, this connects to the next question I wanted to ask you all, which is, if various punitive court practices like these excessive court costs or fees, fines for tickets or money bond, all of these practices that revolve around extracting money from people, they disproportionately harm Black and brown and lower income people. So what steps can the county and the state take to reinvest in anti-racist restorative programs that prioritize community well-being over punishment if they rely on fees from these punitive policies to keep themselves running? Is there just a built-in disincentive for municipalities to not implement kind of reforms that would be less about punishment and more about community reinvestment?
I guess one thing, Annie mentioned this earlier, it's not really clear that we know that these jurisdictions rely on these fees to run, because we don't really know if they actually get more in fees than they spend in personnel and time and so on to get them. To me, the real part of the punishment is not the extraction of the money, although that's huge. It's the multiple times that people have to go before a court and the extension of probation. It's the monthly check-ins to pay $10 on your court costs, fines, and fees. To get there alone can cost more than $10. And then you have to get there and either pay $10 or say, I don't have it today, but risk, if you don't have it, if you don't show up, risk a warrant being put out for your arrest if you don't show up. So you have to go to at least say, I don't have it, because you probably spent it trying to get there. It's this process that is, to me, extra punishing on top of the extraction of the actual dollars. So for me, getting rid of the fines and fees is as much of not extracting the capital as it is getting rid of this infrastructure of collections that also, uses the time of a person with a JD who's sitting there in a court. It just doesn't make any sense. If you go sit in a courtroom and you see this relentless hour after hour of how much can you pay today? $5. Okay, thank you. Go to the clerk's office, pay the $5, come back and let me know. You just wonder, what are we doing in terms of spending our resources? And the punishment that represents for the person, to me, is the particular over abuse of the system.
Anyone else have any thoughts on this one?
You might have to re-ask the question because I might have taken it in a direction that people forgot the initial question.
Yeah, I mean, I was just, the gist of what I was asking was whether, there's kind of this push to get more, less punitive kind of programs to be run through the court, or diversions of various sorts, like alternative courts, to roll back some of the kind of regressive fees and fines that disproportionately harm Black and brown and lower income people. But I'm just wondering if there's like a built-in disincentive for court systems to embrace this kind of thing if they rely on the money that comes in from that stuff to fund themselves. But I see your point that we don't even know how much of that money they rely on. Like before we could even discuss that, we would need to know what kind of money we're talking about, which seems pretty difficult to do. But yeah, does anyone else have any thoughts?
Well, I'll take a stab at the question from the approach of what can the county do to reinvest money or better spend money, which is the hard thing is that the county board that approves the budget has to balance the budget and figure out what all of the priorities are and fit those within the budgets of the elected officials who all control their own operations. And so I feel like a difficult balance to get one agency to give up money for another. And so I think that one aspect of getting to the solution or getting to the funding the things that people want to be funded is having the board have meetings in a public forum with each of the agencies involved, ask questions, and get more information out. That's one of the best ways from a research perspective that I've seen in terms of, sometimes you can ask an agency for information about how they're spending money, but oftentimes doing that in a public meeting before the governing board, I think is a helpful way.
One quick thought with regard to diversion programs, which you mentioned in your question. I think an important thing to think about in how diversion programs are structured, a lot of times the way they're structured is it's a diversion program within the court system. So you're not, rather than traditional prosecution, somebody is being told to attend treatment or something like that. And so some sort of drug probation or in which the prosecutor and the courts is still the sort of overseer of the services, if you will, that the person is supposed to get. And that's still happening within the court system. And it's also asking court actors to bring to bear skills that they don't normally have, managing a person's drug treatment, and so or whatever it might be. And so a diversion program, if we're looking at it, especially in terms of, I think whether we're looking at it in terms of court resources and better allocating resources or just better outcomes for individuals, diversion ought to be an off-ramp from the court system to another system, typically a health system or a community-based service of some sort, and not attempt to cram round pegs into square holes like we do now, where we make the court system the sort of dumping ground of people who need other types of services.
And I don't want to overlook your question about race and racism. So that's super important to put on the table. And I think why your question inspired in me the point that I was making about this relentless cycle of punishment is that in many ways, the police and the court system are doing what they are designed to do. There is historical and contemporary stigma and racism that drives the processing of Black and Latinx people, poor white people as well. We've done this research across the state and interviewing people in rural areas and poor white people in downstate Illinois. You hear very similar kind of frustration from them as you do Black and Latinx people here in Chicago. And it is designed to, it's built on that stigma. And the police over-police Black and Latinx neighborhoods that funnel Black and Latinx people into the court system. Anybody who does any day of courtroom observations in Cook County will see that. And then keeps them ensnared without having these off-ramps into services, the kinds of problems that get them into the court system to begin with, which are problems of poverty, problems of addiction, which are problems of poverty, are also part of that stigma and racism that creates those problems to begin with. They get into the court system, which is a punitive system, and then there aren't these off-ramps back into services. So we're operating in a long-standing system of anti-Blackness that we have seen now, unfortunately, on our TV screens for the last couple of months. And that system reinforces that.
Well, and also, I mean, a lot of diversion programs, I feel like it's like the venue, the possible universe of possible programs is sort of limited by what we can get, you know, like the sheriff's office on board with in terms of like, okay, if we're not keeping people at the jail, what are alternatives? Or again, like the various systems that are already connected to the criminal justice system. There seems to be a willingness for, I don't know, for kind of political purposes to say like, okay, we're providing resources to people in the system. We're providing cooking classes at the jail. We're giving people therapy through the sheriff's office. We're, I'm not sure, I'm not as familiar with this in the kind of realm of the like domestic violence courthouse and what kind of programs exist there, but I'm sure this is also some kind of, this plays a part as well. So I'm wondering if there's actually, as far as the diversion programs goes, as far as the alternatives go, should we be wary of solutions that are presented as like less punitive and more kind of wellness and justice oriented? And should we be paying attention to like who's lobbying to get certain programs into the system as like alternatives? Whether it's the like electronic monitoring companies that are just kind of transferring jail into home conditions, or I don't know, what's another example, or just like the mental health services that are like somehow still connected to the sheriff's office. Wondering about your thoughts on that. Like, how does an alternative actually appear in our court system? Things that are touted as alternatives, how do those things get put in place? And should we be wary of them?
We should be wary of actors and systems that their whole purpose for existing is to dole out punishment, being the venue where a supposed like therapeutic or non-punitive approach is happening. They're not suited to do it. So whenever we see that sort of thing, we should question it. We should say, like, why is a judge and a prosecutor involved if what we're trying to solve is a condition of poverty or addiction or mental illness? Why are these even the right actors to be making decisions about this? I mean, back to the question of off-ramps. We need to get the criminal courts out of the business of doing certain things and dealing with certain things because they're not built for it. They're not well suited for it. They're not trained for it.
Yeah, I agree. I think the sheriff expanding programs into different things that wouldn't normally fall under a sheriff's job description definitely needs to be looked at. And I don't think that they have. And then there was the recent announcement that the sheriff was switching electronic monitoring devices from radio frequency to GPS. I think there's a lot of things that need to be questioned, not that they're being done in a, not that they shouldn't be done, but just to justify those decisions that are being made.
Yeah, I would echo what's been said already about being cognizant of who's offering these programs. We see at like the domestic violence courthouse, folks will be sent to PAPE programs, partner abuse intervention programs, and these are offered by service providers, but there's a very different setting and involvement when someone is court ordered to participate versus they just reach out to a service provider themselves. So even that, and recognizing it, again, as has been said, this idea that the courts were built for punishment, and knowing that and knowing how someone who therefore is court involved will interact with any diversion program or other service when it's still ultimately tied to the courts and there's still this element of punishment to it versus they're being offered a service.
Well, I'm wondering, how can we then avoid falling into this, how can we avoid the pitfall of accepting alternatives to criminal punishment, for example, or like punitive fining, when there does seem to be a political will for it, but the things that end up happening, or the versions of these alternatives that we end up getting, are somehow just like permutations of the sheriff's office or the probation office or whatever it might be. Like how do you organize or lobby for these alternatives to punishment that the system isn't going to just say like, oh yeah, no, we're doing it. We're offering counseling, or how do you just politically move in the direction of decarceration and not fining and imposing fees on poverty, when the politicians know that it's a very palatable thing to be embracing, but then the thing that they do is like just further expanding the tentacles of the system into people's homes, into people's marital counseling, whatever it might be.
I think the lobbying that you're seeing is the social movement that we're observing right now, and that is the necessary, not sufficient, but necessary groundswell of not just protest, but also evidence. I mean, many of the organizations on the ground have generated significant evidence. Much of the evidence that we have right now about police budgets kind of started with groups like Black Lives Matter, BYP 100, many of those groups working with research shops to put some of that evidence out there, and now investigative journalists following up with a lot more information. So I think the political will comes initially from that push, but it has to maintain its intensity, because for example, the legislators, the city council people in Minneapolis initially embraced the idea of defunding the police or abolishing the police. And all of them, pretty much all of them, have walked that back now because there are lots of very invested constituents. Nobody wants the police unions, the police officers don't want their budget to shrink, neither do the sheriff's office. And I think this is an important point to make. I mean, Annie was talking about, we don't really know about the inefficiencies or efficiencies of the circuit clerk's office. And here I put on my other researcher hat. I'm somebody who studies the Black middle class. And I know that the public sector has been an important bedrock of the growth and the sustenance of the Black middle class here in Chicago. And many of the people who work in the clerk's office are African American, especially women. And so I recognize that public sector work, that I don't think it's, that there are employees that make good living wage salaries in public sector jobs. And so the question is not, how can we shrink the public sector? I don't think Annie was mentioning that at all. It's not how do we shrink the public sector or get rid of these, but how do we retrain people across public sector jobs to create a more caring as opposed to a more punitive society? So who in the clerk's office who are now processing these month after month people coming to pay money that they can't pay, who there might be better trained as a domestic violence counselor, as somebody who work in the advocacy for children, as someone who works in food services here in the city, as a housing counselor. So the basic needs of food, shelter, and so on, these are things that we're not meeting. And as a result, people are ending up in the criminal justice system. So I support the public sector, but in caring rather than punitive services.
Well, and it's often not when those alternatives are actually doled out, if it's not kind of retooling the work of existing public sector employees that are within the sheriff's office or whatever to be doing work that's shouldn't even be in their purview. I feel like a lot of times these diversion programs or social work programs or whatever they might be, it sort of introduces, like, even if it's not public sector employee, it might be like some kind of middleman or a contractor or some other like ecosystem of businesses that rely on the kind of transfer of public dollars into their work, but they're not providing public sector jobs that don't have the same benefits, that don't have the same sort of, it's like a double-edged sword where people are not getting any looser from the system, right? But also it's no longer workers within the system that are technically public servants and are publicly accountable that are overseeing those programs.
Maya, the thing that your question made me think about a little bit is the city of Chicago's system of ticketing and then trying to collect tickets. And you know, one entity that has a role to play is journalism, because I've done some work in the area of in coalition with Appleseed and some other organizations on helping to pass a law to get rid of driver's license suspensions for failure to pay parking tickets. And the problem, and you know, the sort of the racial disparities in where tickets are being issued and the people who are being impacted, all of that was revealed through some great reporting by WBEZ and ProPublica, and sort of showing where the city is generating this, or where they're doing these activities that are supposed to be generating revenue. But in working on that project, we've just sort of learned about there are many different departments, including the police department in the city, that are issuing tickets that are part of this collection apparatus, and they overlap and they don't necessarily know what each is doing. And meanwhile, they're trying to collect tickets that were issued like 20 years ago with all the sort of intervening late fees and stuff that have have been applied in the interim. And so we have all of these city workers who are part of this apparatus. I think, there's some evidence, and if there was more transparency, I think there would be more evidence that a lot of these people who are sort of charged with being cogs in this ticketing and collection apparatus, which is totally not clear what the return on investment even is. I think the question that was raised earlier about how much are they spending to erect this apparatus and keep it running, as opposed to like what they're actually bringing in. I think there's a lot of excess in the system, and these people, I'm not saying they don't need to be employed by the city, but they could be doing so much more productive things for the people of Chicago.
Olivia or Alexandra, do you have any thoughts on this issue of kind of third-party actors and diversion programs, and how we can kind of both, take people out of the court system and sort of reduce the involvement of the criminal justice or the civil courts in people's lives, without simultaneously creating like a whole other ecosystem of businesses that continue to somehow keep them involved?
Yeah, I think this kind of been spoken to a little bit already, but a lot of it is just providing the resources so folks don't end up in the system in the first place. So, if we need a diversion program that feeds into mental health programs, how can we provide mental health resources in advance of someone becoming court involved? How do we fund the community services? And there's conversation we see a lot around defunding the police, this idea of reinvesting those funds into the community, into services that help prevent folks ending up in the court system in the first place. I think by funding those systems up front, it takes away that need to rely on these third parties that are ultimately tied to the court systems.
Yeah, I think Olivia is absolutely right about that. I just wanted to jump in with a somewhat smaller point that people may not realize, but the Illinois Supreme Court is the body that processes applications and approves alternative courts. So in terms of where do we apply pressure, that is the central clearinghouse. They have standards for diversion courts that we should be taking a close look at. But the way these diversion courts operate is essentially they're not necessarily in name, but in effect, always pilot programs. They are very small efforts, very locally run. So even though they're approved by the Supreme Court, there is not one sort of coordinated statewide effort to divert people from the court system. So I think, the idea of keeping people out of the court system to begin with is not something that the Illinois Supreme Court or any individual court can be charged with. That is a state level policy issue that ultimately is the responsibility of the legislature and the governor. I was very heartened to see Governor Pritzker's announced priorities for rebalancing the criminal justice budgets and criminal justice reform. They are great in theory. I hope they become implemented in practice through state legislation, either in this veto session or next year.
Has there been any, research or findings that have come out at this point about the effectiveness of these alternative courts and diversion programs? Like, what do we know about trying these alternative, less punitive methods of engaging with folks who wind up in the justice system? Has not enough time yet passed to really be able to kind of judge the impact or efficacy of these programs?
I think one thing that we know is that we have to, while certainly there's room for people to try new things, when you're implementing diversion programs at scale, they should be evidence-based. There should be a reason to think that it's going to work because the model has been tested, but then there needs to be fidelity to the model. And that's where you see a lot of these things get off track. For instance, there was a drug court here in Cook County in the city of Chicago that was founded on a model from Hawaii that had up to that point had shown some pretty good results. I think some of the later research has cast doubt on that. But anyway, it was implemented here in Chicago in a particular judge's courtroom, and that judge was not adhering to the model with fidelity. She was doing her own thing and on an ad hoc basis, and the results were poor. And ultimately, the state ended up pulling funding from that drug court because the chief judge here in Cook County wouldn't shut it down. But that so it's only as the program is only as good as the model and the degree to which it is implemented with fidelity. And I think judges are not necessarily they have a lot of autonomy in their courtrooms, and there's not a lot of things that we can do to hold them accountable to do that, which is another reason to, I think, in support of the idea that maybe some of these things ought to be taken out of the courts altogether.
I think one of the challenges for such alternative courts. So as part of this research, I observed a drug court in a part of Illinois, and it's still in the court. It's in the courthouse where the same defendant had been sentenced, had a case that was prolonged, had been offered a plea deal that perhaps they weren't as happy with, had been sentenced to pay fines and fees. There is so much skepticism, cynicism. It's not like defendants come before the court now that it has changed into a drug court thinking, now this is a safe space for me. Now this is a loving space for me. Now this is a supportive space for me. Not at all. There is still a judge who holds the person's fate in his or her hands. There is still a prosecutor. There is still a probation officer. It is still surveillance. It's still punitive. At any moment, the rug could be pulled from under them. I was very interested focusing this research on fines and fees in how, for example, they organized days where they would do community service as a group, the group that was in this drug court, and they would get a reduction on their fines and fees, $5 for the 4 hours they worked or whatever the formula is. And, that was celebrated. Interestingly, in the court, what I was amazed at as a researcher, there's a lot of performance in the court. The defendants are very, they're performing I will get a job. I am working on, this is what I'm working on. There's a lot of this performance. And then when you interview them afterwards, there is a lot of cynicism about the performance that they just did and how much this is really a caring effort, how successful it all will be. So I think, again, back to Benjamin's point from the very beginning, supposedly putting a smiley face and a hug on a courtroom apparatus is not going to be productive, I think, in the long run.
Well, actually, if there's the example that I think of a lot when this is discussed is actually, and maybe Olivia, you could speak to this on a little bit, because I feel like this was actually in Arizona or somewhere in the Southwest, where there was this whole big alternative program that was put on to directed at sex workers to try to like divert them from some kind of sex trafficking or human trafficking pipelines. And this thing was like celebrated and touted as like this big non-punitive kind of thing. And then it turned out some years later that like actually like the nonprofit that was working to provide those services was, deeply connected and entwined with the criminal punishment apparatus. And then there were all kinds of pitfalls along the way that were people could kind of fall through the cracks and end up right back in the kind of punitive system. It seems like a lot of these kinds of programs, these alternative programs that are like very rigid, and it's very easy to sort of flunk out, because it's like it's set up to be like rewarding good behavior, but it's very easy to just kind of, because it doesn't change the social circumstances on the ground that people are living in, you just sort of like get an opportunity, but then nothing about your life has made it so that you're able to like to take advantage of it any more than you would have before.
Yeah, I don't know too much about that specific program, but I think this idea that folks, are always fearful when they're in these programs that ultimately they're connected to the court system and they can feed back in at any time really leads to this distrust, and especially for folks who have maybe been system involved for a lifetime, to ask them to trust in a system that is ultimately still tied to a court that's maybe asking them to do a lot, has a lot of rules and restrictions and a lot of ways for them to fail. It's really hard for them to engage in. And again, it's ultimately still punitive. If, there's a way to fail out of these programs that put you back into a courtroom, it's discouraging, it's disheartening, it's not really a true program that folks can engage and feel safe in. It's not as I said, a smiley face and a hug makes it all better when you can still end up right back where you would in another program.
Okay, I want to also ask a question about so we've discussed how, this notion that the court systems are kind of super cash trapped and there's not enough resources. It's worth questioning that, because actually we don't know how cash strapped they are and how they allocate their resources. But in terms of actually funding our courts and court services and all of the other elements of the local criminal justice system that are all funded by the county, like governments are constantly saying that the alternative to fines and fees is property tax hikes, and voters won't accept those property tax hikes. So I'd be curious to hear you kind of talk about this claim and whether you believe that, is it correct to think that voters would never accept higher property taxes to pay for our court system? Or is this just something politicians tend to trot out because, it's convenient for them to say that it's like not politically feasible to raise property taxes? Cook County has had a property tax freeze since the early 90s, and they haven't even taken any inflation adjustment. They haven't taken any more money even to adjust to inflation, even though they're entitled to do that. So I feel like if truly the funding is coming from these fees and fines, the more equitable alternative to that would be to rely more on property taxes. But it seems like always a non-starter. And yeah, I'm just curious to hear what you think about that.
I can take a stab at that first, and then others can chime in. Yes, you're right. Cook County has not chosen to increase their property tax in many years, although the city of Chicago has, and Chicago Public Schools both have implemented very large property tax increases in recent years. So in terms of if voters would go along, I don't know, but it definitely seems like the Cook County Board could use that as a tool, but they have chosen not to. Yeah, it's a tricky question because if you can show what a property tax increase is going to be used for and why it's necessary, and why there is not a better alternative to that, then people might be more palatable if it's formulated along with a plan, what it's going to be funding. As an example, the Cook County increased their sales tax by saying that it was going to be funding the pension fund. And so it had a plan that went along with it. I think that helps to put context in terms of if government needs more money, they need to show what it's going to be used for.
But do you think that it's more so the rhetoric of politicians who don't want to be perceived as being pro property tax, or is it really not possible to fund the court system more equitably through property taxes? Because especially lower middle class folks, property owners who are lower middle class, property taxes are can be extremely onerous. But if at the same time, as Mary was saying, this is, for example, in the Black community in Chicago, these county jobs are kind of a pathway into the middle class, and they've been like a kind of solid source of employment and good union jobs for so long. Wouldn't people be more open to the idea that okay, we need to increase the property taxes to keep funding the system that that's employing so many people? Could it be an easier sell than the politicians would have us believe?
Well, I guess I'm quiet because I'm not sure it's the right question. I feel like if we begin with decreasing policing budgets, that would have ramifications in the court. So the over-policing is what crams up the court with so many of these minor cases that then drag on for years, months and years, that create more work in the court system. And the police are obviously incentivized. Again, speaking of the excellent work of reporters, there was a recent report about even what some of these anti-violence task forces have been doing. And they've been writing tickets and doing very little getting guns off the streets. And those things feed into the court system. And I think this over-policing on minor offenses is where we first need to start decreasing the money that we need. So I think it's totally premature to be thinking about property tax increases to increase funding at the court system, but rather decreasing the size of this part of our system overall.
Yeah, I totally agree with what Dr. Patillo just said, and I'm going to take a dodge on the property tax question, in part out of ignorance, but also I think it kind of comes back to this question of, is this user fee model the right model? When you talk about would voters buy into paying more taxes if it funded a better system? I do think we need to think about our courts in a different way, where we need to think about the courts are there to provide access to justice for everyone. And they need to be accessible, and we need to think about the things that the courts need to provide. So earlier it was mentioned there aren't enough foreign language interpreters and the services that you need to run courts well. And so like the starting point should be, what do we need there, to have the functioning court system that provides access to everyone, because that's what courts are there for, to provide justice for everyone. And how do we provide stable funding to keep those things in place, as opposed to trying to squeeze as much money as we can squeeze out of every individual who walks through the door, which just, so, the funding of the courts is automatically contingent on how many cases there are, and which fluctuates, based on a whole lot of different things. And it's just, that's no way to fund a system that is meant to provide justice for all the people. So whether it's property taxes or it's some other source, I guess I'm suggesting we need to get away from fines and fees as the user fee model for funding the courts, and find a better, more stable and consistent source of funding, whatever
and
that
to
might be.
illustrate the churn, Kim Foxx decided maybe 3 years ago not to prosecute cases where people's driver's license were suspended for non-payment of fees. But she decided not to prosecute them, but it doesn't mean that the police weren't still funneling people into the court system. So when I would be sitting there doing my courtroom observations, there would be case after case of somebody driving on a suspended license where the prosecutor would then dismiss that charge. This is just hours I would be sitting there that this would be happening. So that, again, the funneling from the police side, who's incentivized to write tickets and to get people into the criminal justice system, but then the lack of coordination with Kim Foxx's office, who's decided not to prosecute these things, it's just a big waste of money.
And the root of the problem seems to be that there's this like bifurcation, and like the county is responsible for all this stuff, but then the city government is responsible for the policing. And as long as those two separate government entities are running these two different parts of the systems, they can finger point all they want to say, like, when something goes wrong, oh, it's the judges that are letting them out of bond court, or it's the sheriff that's letting people out on electronic monitoring, or on the other side, they say, it's the Chicago cops that are the problem. I don't even know what kind of solution can you imagine when the part of the problem is this like separation in which units of government are running which part of the justice system.
Well, I think part of the solution to that is a full reimagining at the state level of, building on what Ben was saying, a unified court system. There is no reason why we should have separately elected officials who are in charge of the sheriff's office, the courts, the clerk's office, the city level, the county level, the state level. I've practiced law in many other jurisdictions. Most other jurisdictions do not operate so inefficiently. I think a lot of it is probably a relic of Illinois patronage politics, where everyone wanted a separate office and they could hire their own people. And the time for that has long passed. There are many efficiencies that could be achieved by creating a rationally run unified court system where, the clerks are absorbed into the administrative office of the courts, for example. Why should we have the sheriff in charge of the jail and then the CPD in charge of Chicago police? And there is so much kind of overlap and inefficiency that really could be wholesale reimagined at the state level. There's no reason why we need 20-something different judicial districts all operating their own IT systems, their own purchasing systems, not to mention their own forms of justice or lack thereof, their own, fines and fees and collections. It's really a mess. It's, as Dr. Patillo started out the whole program pointing out, it's completely non-transparent and impossible to navigate for an individual who's trying to litigate a civil or criminal case. It wastes an untold amount of money that really is impossible to figure out because we don't know where it's going. But it's, the efficiencies to be gained are palpable.
Is there a good precedent somewhere where a system that's like as Byzantine as ours was kind of restructured and made more efficient successfully? Because what I often hear is that, like, well, things are so kind of all over the place and messed up in Illinois, and there's a million different elected officials, and there's so much corruption and patronage. And then there's other places where it's not like that. But are there any examples of places that were like that that became not like that? Or are we just kind of in our own separate ontological category of like, this is a place that runs this way and everyone else is in a different boat?
I don't know if you're directing that to me. I don't know of historical examples. There are procedures to be followed, sort of small examples for, a township to dissolve itself and become part of a larger entity within the state of Illinois. Those things happen. I think it's not a failure of method or possibility so much as a failure of political will, because people who are elected officials stand to lose power, stand to lose money in their budgets. So it is a failure of political will and leadership, I think, more than a failure of the existence of any precedent to follow.
So the study that I'm a part of is an 8-state study across the country. And so I'll say actually Illinois is kind of in the middle. There are much worse examples in Illinois. It's interesting, Illinois in some ways is a unified court system in comparison to places that have hundreds of municipal courts, for example. And we have administrative jurisdictions, but not part of the court system, that unified court system. In Georgia, probation is privatized, for example. At least here, probation is part of the court system. So Illinois really is kind of in the middle, with perhaps the best of our 8 states being Minnesota. So in one regard, Illinois is similar to Minnesota in that we do have somewhat of a unified court system, so not these municipal courts. Minnesota has a much more, I think Illinois has moved to this, but a much more blanket system of fines and fees. So in the most recent Criminal Traffic Assessments Act, Illinois moved towards more uniformity across the counties, which we're still trying to see how far that uniformity has gone and how much the practice is being followed to the law. But that's more in line with, for example, how Minnesota has done it. It has a very unified schedule of fees and a clear schedule of fees that should be charged in any part of the state. So that's one model I would put out there, but it is important to recognize that Missouri, for example, Georgia, have much more decentralized systems than we do. One other model I'll say is Washington State, as a result of a Supreme Court decision, mandates ability to pay hearings for all people in the court system, which seems to have had the effect of finding that a lot of people just can't pay their fines and fees, but interestingly also has had the effect of really sensitizing judges to that fact. And here in Illinois, in our interviews with judges, they, by and large, the judges that we have talked to, are not like huge supporters of this monetary sanction system. They find it also inefficient and confusing and not a central part of what they want to do, but they say it's in the law and so they have to do it. But this mandating in Washington as a part of a Washington Supreme Court, state Supreme Court decision to do ability to pay hearings, I think would further sensitize judges to really the non-starter nature of assigning fines and fees to many of the defendants who come before them.
One thing I wanted to interject really quickly that comment made me think of, one of the things in the Criminal and Traffic Assessment Act that Dr. Patillo mentioned was the ability of judges to waive fines in criminal cases, which they're doing. One thing it didn't contain was the ability of judges to waive fines in traffic cases, which I've heard from at least one judge they would very much like to do, but are not allowed to do. And I know from some of the debate around that in Springfield that part of the reason for that is complaints by the Law Enforcement Training and Standards Board, whose training budget comes out of traffic tickets. Especially at a time when we're trying to rethink policing and the role of the police, I think the question needs to be asked, why on earth should the amount of funding available for police training hinge on the number of traffic tickets that are handed out? The two things have nothing to do with one another. It provides an incentive to give tickets. It's just, we should fund police training if we think it's an important thing in another way. And it's having all of these downstream consequences with people having lost their driver's license and they can't get it back because of some traffic ticket that they don't have the money to pay. And so those are some of the ripple effects.
One thing I want to add that your question made me think of, we were talking about judicial structure, which I can't speak to that, but I can speak to a survey that Appleseed did with the help of pro bono attorneys looking at access to information, in which Illinois is a total outlier when it comes to how much, if anything, is accessible under public access or Freedom of Information Act laws. And I think in some cases that was because of the way that other states' judiciaries were structured, and differences between Illinois and some other places. But in general, at least in most other states, you can at least get some statistical or budgetary information through public records laws.
Well, so we are almost out of time. One more question I want to ask, and this can be kind of a fast round, I guess. But so much of what we've talked about in terms of like policy change or restructuring how we finance the court system, these are issues that are sort of separate from the culture that exists in the courts, especially among judges. And so much of how the legal system functions ultimately comes down to like how a judge decides to run their courtroom. And you've all brought up examples of how individual and different a program can be, how individually different a program can be depending on the judge that's running it. So I'm just wondering, what kind of policy can help change the culture of the courts? Because if we have judges that are buying into a kind of a punitive mindset or racist stereotypes about people, and if they're free to implement everything from like sentencing laws to whether someone seems contrite enough, whether they're really working hard enough to get a job in an alternative or diversion program. If they have so much if so much depends on how they view people and how they're used to working, what kind of policy could we implement to really impact the culture of the courtroom, which is like built over generations and years of people working in the system?
Well, the Administrative Office of the Illinois Courts has a training session for judges. I don't know if it's annual or biannually, and I've presented to that where we did a session on, there is an Access to Justice Committee, for example, and we did a session on poverty in the criminal justice system as a way to try to sensitize judges to the population that comes before them. So I think that's important, but I also don't think we should minimize the role of prosecutors in this scenario as well, because yes, you're right, judges set the kind of tone of the court and prosecutors work within that, but prosecutors have a lot of discretion in how many charges they're going to bring forth and in their plea bargaining and so on and so forth. So I guess I'm talking about training, but my larger answer would be way more bold than that. I think that's super constrained. I think the system is perhaps irretrievably corrupt and built upon some a kind of anti-Blackness that I've talked about, that I worry that we really have to do the bold reimagining that many of the folks at the forefront of the contemporary protests have put before us.
You asked a really tough question, and the best answer I have for it, and it's not a complete answer, but as far as how we change the courtroom culture, that, as you said, the tone is set by judges. Well, we have the opportunity to vote on judges, and like whether they're retained or not. And too often, that's just been a rubber stamp. Like in this election and the one before it, you're finally seeing some scrutiny on the actual record of these judges and public campaigns to either retain or not retain a judge. And that's one way we can change the culture: get rid of the judges who aren't setting the right tone.
I agree with Ben and Dr. Patillo, and I will also add, judges are part of our culture, and because they are elected, they reflect the electorate. And so one of the boldest things we can do is become educated and anti-racist voters and activists and community organizers, and support and participate in organizations like Chicago Appleseed and the Chicago Council of Lawyers and the other organizations, the ACLU and the Civic Federation, who are represented here today, because courts ultimately are responsive and a part of our society, and they won't change until society changes.
Okay, if no one has any last thoughts, I want to thank all our panelists once again for joining us. Hopefully this was an informative discussion for all of those who've been watching. And again, the Collaboration for Justice is hosting panels all month on various topics about making our justice system more just, and you can find information about the other panels that are going to be happening throughout the month at collaborationforjustice.org. Thank you all for joining us.
Thank you.